What if you could flip the script on a debt collector or lender and force them to prove every single detail of the claim against you before you pay anything? What if I told you that there's a legal way to challenge any debt and make a creditor prove everything while offering payment without ever going to court? In this video, I'm going to be breaking down the conditional acceptance process along with how to pair it with a payment voucher and how to essentially challenge debt and settle obligations lawfully. This strategy works because it puts the burden of proof on them, and it is backed by contract law, the UCC, and your right to settle debts, whether you're going to do it in the private or in the public. Okay. Now, once again, I want you guys to know that I've been studying consumer law for the last 3 to 4 years. And essentially, with consumer law, the UCC, and contract enforcement, I'm here to show you a strategy that most lawyers and debt collectors hope you never learn. So make sure you guys have your notebook and notepad. Also, at the same time, this is not legal advice. This is only for educational purposes only. Do your due diligence. You dig me? If you do your due diligence, then everything will make sense. All right. I'm also going to be cross-referencing this with actual laws and regulations that are easily seen and easily read online. Okay. Now, if you're brand new, make sure to subscribe to the channel. Okay. Turn on those post notifications because I do post daily content. Secondly, if you are returning or you're brand new, make sure to like the video as well. If you like the video, you subscribe to the channel, you are putting a free investment into me that lets me know that you guys like the content that I'm putting out. And also at the same time, this will promote and push me to create more content for you guys. All right. Now, what I want to do is I want to talk a little bit about the aspect of conditional acceptance. Okay. And essentially, when you understand conditional acceptance, then enforcing your negotiable instruments become much more easier. Okay. A lot of times people will say, oh, the debt collector ignored me and this, that, and the third, or the debt collector didn't want to accept it and this, that, and the third. But the thing is you essentially hold the power when you understand conditional acceptance, because, and I'll talk about this, but long story short, I mean, just to put it in layman's terms, look, man, I'll unconditionally accept this offer, or I'll conditionally accept this offer under these conditions. Okay. And there's a unconditional and then there's a conditional. Okay. So under certain conditions, I'll accept this offer. Right. But when it's unconditional, now we're on the aspect of, okay, there is no conditions. You either follow this or you don't get what you want. Okay. Essentially now becomes a demand. All right. Now, conditional acceptance is one of the most powerful tools in contract law. And it essentially means that you don't say no, you say yes if. Okay. If you can provide me something, then yes, yes, yes. But if not, then it's no. You are refusing. So, I mean, so let's dive straight into it. Now, to break down conditional acceptance in layman's terms, essentially, number one, when you send a letter, okay, you are essentially saying, you are not saying no, you are saying yes if you accept their offer on the condition that they prove specific claims. That's one. So if they say that you owe a debt, then you can essentially ask them, hey, I will accept this if you can prove X, Y, and Z. Okay. Number two, it flips the burden of proof to them, making them respond to your terms now, because now you have created a contract for them to respond properly to what you asked them for. Okay. When you ask someone for proof, they have the obligation to give you the proof. Then we dive into, if they fail to answer point for point, you can treat it as a dishonor or a non-performance of a contract. Now, the laws that back up conditional acceptance, or this very process here, is UCC 3-501, okay, UCC 1-308, and then UCC 3-505. Okay, and then we're also going to talk about the common law principle that nobody talks about. So let's dive into 3-501. Okay, specifically B. Okay, The following rules are subject to Article 4 agreement of the parties in clearing house rules and the like. Okay? And we're going to go straight down to 2, where it says, upon demand of the person to whom the presentment is made, the person making presentment must 1. Exhibit the instrument. Number 2. Give reasonable identification, and if the presentment is made on behalf of another person, reasonable evidence of authority to do so. And number 3. Sign a receipt on the instrument for any payment made, or surrender the instrument if full payment is made. So let's break this down in layman's terms, because a lot of times we do not fully understand the information that is given when it comes to this. Okay, let me take one of these off, man, because the marketing is done. Okay, if you're gonna stick around, you're gonna stick around no matter how many chains I got on. Okay, so first things first, let's dive into UCC 3-501 B2, which is the tender of payment. And essentially, what it says in legal terms is that when someone makes a payment or presents an instrument like a check, note, bond, they are offering to settle the debt. If the person who's owed money refuses it without good reason, that can discharge the obligation. Okay? Now, understand that what it means is that if you offer to pay a debt, even with a legally valid alternative method, and they refuse the payment, they lose the right to collect. Okay? And essentially, it's like saying, I tried to pay you and you didn't accept it. That is on you. Okay? I gave you a lawful way to pay something and you decided not to take it. That is on you. Okay? And you're protected under the commercial code. Okay? So a lot of times people will say, well, they didn't accept it. Perfect. They just literally discharged the debt when they didn't accept it. Thank you very much. Okay? Then we dive into C1-308, which is performance or acceptance under reservation of rights. Okay? It says that a party with explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Such words without prejudice, under protest, or the like are sufficient. Okay? This subsection does not apply to an accord and satisfaction. So, long story short, what it says is that you can perform, UCC 1-308 says that you can perform or accept something like signing a form or paying under pressure, dig me, without giving up your legal rights as long as you're reserving them. Okay? So if you get in a contract that you feel like you are signing under duress, just put something like without prejudice, under protest. Now be very strategic and be very strategic when using signing in this way, because a lot of companies and a lot of creditors catch on this and they try to essentially cancel the contract because of it and say, oh, well, this is not typically people who sign like this give us problems. And that's probably the truth. They can't double dip on those people. Okay? And I'll make another video on how to be able to fight against that. But it protects you from being tricked into giving up on your rights. So if you write or say without prejudice or UCC 1-308, it means I'm doing this, but I don't agree to give up my rights and I don't accept anything that harms me. Okay? So on the aspect of them either double dipping or going to, do anything that can be harmful to you or to your detriment, you're essentially saying you're not agreeing to that. Okay? So we're talking about a bill that has to be paid over time or interest that isn't you don't have to pay certain things. You reserve your rights. When you go into court and you say, hey, well, I didn't know that this is something that I needed to do, and for some way, in some shape or form, they are trying to say that I agreed to it, but I never did. I agreed to get my car. Okay? I agreed to sign this promissory note so that they can exchange it for value. Okay? Then we dive into UCC 3-505, which is the evidence of dishonor, where a lot of people will say, well, they ignored me. Perfect. If they ignored you, then you know exactly what to do. You want to call them out on their dishonor. And so long story short, the evidence of dishonor, it says here that if a payment or instrument is refused or not honored, the person who refused it can be sent a notice of dishonor, which legally documents that they rejected lawful payment. So the point is, when someone rejects it or ignores you, then you want to notify them of their dishonor, okay? Because they have to perform on this contract, okay? So essentially, what it means is that if you offer a valid form of payment and they ignore it or reject it, you can send them a legal notice that says you dishonored this contract. You rejected lawful payment. It creates a paper trail to protect you and hold them accountable. So this is the whole point of sending letters through written form, so that you can create a paper trail so that you are protected. If they ever try to take you to court, and this is not legal advice, but this is for educational purposes, if they ever try to take you to court, you want to use this notice of dishonor to say, hey, look, well, I tried to reach out to you guys. You guys didn't even send me a letter back accepting or saying that you refused it. So I assumed that you either accepted or refused it. Okay? When they don't respond, it's called tacit assent. Okay, and you can assume whatever it is that you want to assume at that point in time. Okay, but the way that you create your own paper trail is to send them a letter of dishonor, or in other words, notice of dishonor. Okay, then we dive into the contract law principle, because people don't know that this is all based off the premise of common law and contract principles. Okay, so common law contract principles developed through judicial precedent require valid offer, acceptance, consideration, intention to create legal relations, capacity of parties, and legality of purpose for a contract to be enforceable. So all these things have to be in line in order for it to be an enforceable or valid contract. So it dives into offer and acceptance is a piece of a contract. It dives into the aspect of consideration. It dives into the aspect of intention to create legal relations. It dives into capacity. It dives into legality. It dives into the certainty of terms, mutual assent, stare decisis, common law versus UCC, role evidence rule. And the whole point of this, okay, these are the things that should be in place and should be disclosed and should be apparent when you sign a contract. If you sign a contract and even after the fact, if none of this stuff was apparent, what's going to happen is it becomes a unenforceable contract. So, number one, if it doesn't have an offer, clearly, okay? Number two, it doesn't have an acceptance of that offer. Number three, full disclosure and a mutual understanding. And in other words, some people will say meeting of the minds, meaning that you and I both know what it is that we're contracting to. And number four, a lawful consideration. Something of value must be exchanged. If something of value is not exchanged and there is no meeting of the minds and there is no full disclosure, then it's not a valid contract. And I should ask you, how can you contract with a entity that is not even a natural, living, or breathing person? If you didn't disclose that to me, as a matter of fact, you cannot contract with the dead. So how can you meet minds with the dead? Okay? This is how they put you in a position of waiving your rights and try to use your straw man against you. Okay? So essentially, another thing that we want to talk about is the aspect of that the fact that you can't be bound to a deal that you didn't fully understand, agree to, or receive something in return. So most cases, when it comes to loans, when it comes to these loan agreements that they say that you agree to, I agreed to get money. I didn't agree for you to sell my promissory note and not tell me and then come after me for the money that you just sold. Okay? I didn't agree to you not disclosing how you was going to use my promissory note and how you was going to double dip on me. I never agreed to that. Where in the contract says that you was going to sell this and then come after me for the debt. If you can prove that to me, or you can even prove on the simple fact that I agreed for you to give me $100,000 and you decided to type in those numbers in my bank account and not actually loan me money. I agreed that you was going to loan me money, or I thought you was going to loan me money. And because I didn't know that, I didn't have the capacity, the understanding that you wasn't going to loan me money after the fact, when I find out that you never actually loaned me money, now I recognize that I didn't have the capacity and we never met in minds. We never even had a meeting of minds or a mutual assent, a mutual understanding of what was actually happened. You knew what you was going to gain from it, but I didn't know exactly what I was going to gain from it. Everything that you have done has been to my detriment, and you've only gained and I didn't. And not only that, you have double gained. This is the mindset, because if there is no full disclosure or you didn't knowingly agree, you can challenge that contract. I don't care what type of contract it is, you can challenge it. And this is what lawyers, this is what debt collectors, this is what companies don't want you to know, because they want you to still be in a situation where you think that you cannot be above them. But the thing is, you are above them in many cases. As a matter of fact, it's not even a many case thing. I mean, the only reason you are not above them is because you don't have the knowledge and understanding of the system. Okay? So, just to break it down. Okay, C3-501, you have the right to offer payment, and if they refuse, they may lose their claim. Number 2, UCC 1-308, you can protect your rights under any agreement by reserving them. Number 3, UCC 3-505, it says that they can reject your lawful payment and you can document their dishonor. And number 3, the whole premise of contract law, which most contracting parties understand and should understand, and if they don't understand, then that is on them. No agreement is valid without full understanding, and equal value is exchanged. So I have to ask you, when you signed that loan agreement and they never even gave you the money that you signed for, but they was able to make triple times, quite 10 times the money off of selling your promissory note as a financial asset, and you are just left with just paying them back something that they never lent you, is there an equal consideration? Was there an equal exchange? No, it wasn't. Then we dive into the question of, what is a payment voucher? Okay, how do I pair it with a conditional acceptance? When you dive into 3-104, which is negotiable instrument, it defines a negotiable instrument meaning a unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order. So the whole point of a negotiable instrument isn't just a dollar. It's a order. It's a promise. It's an IOU. Okay, and they can actually monetize your IOU because this is a credit system. Okay, none of this stuff is backed by gold, silver, or actual lawful money. The legal tender can literally be a promise. Okay, when you look at the Federal Reserve note, the dollar, the $20 bill, the $1 bill, long story short, it's going to say that it's a Federal Reserve note. So they borrowed it from the Federal Reserve. Okay, so when we dive into a payment voucher, we dive into remittance coupons, we dive into bonds, we dive into negotiable instruments. Okay, so a document that acts as lawful tender of payment sent in response to a debt claim. So if someone says you owe a debt, this is when you can send them a lawful tender of payment through any of those channels. Then we dive into, it can be created by the trust, private entity, or even using the original billing coupon. So if you have that coupon, remittance coupon, or if you have a trust, a private entity set up, you can actually create your own debt instruments. Okay, and you can do this without the private, but you have different advantages when you do it from the private. Go check out my last video if you want to know and understand how to create your own private trust. Number 3, when paired with conditional acceptance, it creates a paper trail that shifts the liability. See, you want to change and shift the burden of proof. Okay, because when you are saying, hey, I'm not refusing to pay, okay, I'll pay on the premise that you approve everything and process this tender lawfully, then now they have to make sure that they do their job. You did your part, so now it's time for them to do their part. Okay? Prove to me that I actually have to owe you a debt, and prove to me that you never actually monetized or made money on my debt. Okay? Now, A lot of people will be, well, damn, Nicholas is really giving some deep game right now. Look, I'm gonna put it to you like this, man. We 20 minutes in. I may cut this video up, so it'll probably be much shorter by this time. But what I want you guys to do is, if you haven't already, like the video, okay? Also, at the same time, subscribe to the channel. You dig me? If you stay all the way to the end, I will give you guys access to a gift. All right. Now, let's dive into when and why to use this strategy. Okay. Because a lot of times people don't understand how to utilize this strategy. So I'm about to tell you guys exactly how to use this strategy properly. Okay. Number one, use it when a collector or lender sends a demand for a payment. Typically a debt collector, typically a bill, typically any of those situations where someone is trying to collect the debt from you. Okay. Anybody who is trying to collect debt from you falls under the Fair Debt Collection Practices Act. Okay. Number two, you are challenging a bill, loan, or debt with questionable origins. Okay. Be very specific when you are challenging them and ask them the right questions. Number three, you have sent a debt validation and they continue to collect. When you send a debt validation, yes, you are challenging a debt. They may send you a letter saying, oh, you agreed. This is when you want to start challenging them and using the conditional acceptance process and challenging them on the contract. Okay. And number four, you want to create a private record of settlement attempt. Okay. This is the whole point of the conditional acceptance process. This is the whole point of you sending your own written letters. A lot of times people do not do this, and this is why they end up going in court trying to fight a case that they didn't even prepare for. They didn't even do their own private settlement. Okay, if you try to do things in your own way first, you have better advantages in court. This is not legal advice. All my rights are reserved. Okay, UCC 1-308. Okay, may have said the wrong thing. Yep, I was perfect. All right. A conditional acceptance isn't a denial. Understand that, you guys. It keeps you in honor while giving you maximum legal leverage. Okay. So a lot of times people will send in their coupons and things in that nature, just the loan, but they never send some type of notice of tender and add some aspect of conditional acceptance to them. And this is why when they send their letters to the company and they turn their lights off or they repossess their vehicle, they haven't really asked and challenged them on these things. Okay, haven't sent them the notice of dishonor, haven't tried to enforce. And this is why people get stuck in positions. And this is why I tell people, do not do this process if you're not going to do your due diligence. Understand the concepts that I'm talking about, fully understand them, put the letters together, and be able to go the distance and accept the risk that can happen. Because again, through everything, there's a risk. Okay, so if you get empowered to, oh yes, I'm about to stop paying my bill, be ready to start doing the due diligence and sitting down and taking the hours, putting that 60 hours a week to understand how to do this properly so that you won't be in a situation where you are putting your family at a detriment because you didn't want to learn and understand how to do this properly. Okay, you did it off of impulse. And I don't want anybody doing it off of impulse. I want people to do it off of overstanding, okay, and understanding. All right. You have to overstand, you have to understand me in order to take advantage of the consumer law and the administrative process, okay? When you have that confidence in the process and you have that confidence in your evidence and your positioning, then you'll move with that energy and debt collectors and banks will be able to feel that, okay? Now, let's talk about, and this is my gift to you. Let's talk about how to draft a conditional acceptance letter, and I'm going to pull up this document for you. How you want to put together a conditional acceptance letter, you want to make sure to hit these key points. And you know, the crazy thing is I am not afraid to give you guys the game, okay? Because my goal is if you can get the game and you can start challenging these creditors, then we're in a better position. Okay, this is game that people charge you thousands of dollars for, and I'm about to give it to you right here. So if you made it all the way to the end, comment the word discharge, comment the word conditional, and let me know that you got all the way to this point so that you can get this free game. Okay, number one, step one, draft the conditional acceptance letter. Okay, You want to address every point of their claim. Include language like, I conditionally accept your offer to pay this alleged debt upon proof of the following: proof of the original creditor, copy of the original wet ink contract, chain of custody of the debt, validation under FDCPA 15 USC 1692G, full accounting and ledger, disclosure under the Truth in Lending Act 15 USC 1601. Okay? These are some laws that essentially back up the aspect of contract law, debt, lending, things in that nature. And these are valid things that you can ask to any debt collector. Okay. Number 2, you want to include that lawful payment voucher. Okay. This could be a remittance coupon, a private bond or negotiable instrument, a document issued by your trust or private entity. Whatever the case may be, when you understand what a negotiable instrument is, then you create it, you want to include it with the conditional acceptance. And then on top of that, you want to reference the UCC 3-603, which is the tender of payment. Okay. After you do this, you want to send it certified mail or registered. Okay. If you can do registered, that'll be best, because sending securities, it becomes more insured. Okay. But whatever the case may be, you can send it certified regardless, because it is still a contract being created and it's still creating that paper trail. That's important. Okay. Keep copies, track the delivery, and if they don't respond or refuse the instrument, they dishonor the contract according to UCC 3-603, according to UCC 3-505. All right. And essentially, you want to follow up with that notice of dishonor if need be. Okay. You want to reference UCC 3-505, like I just mentioned. Give them a set time to cure and document everything for your legal protection. This is how you properly put together a conditional acceptance. This is how you go through the conditional acceptance process. Yes, we did it real fast, but this is something that I'll include in the Complete Debt Guide. Anybody who taps in with the Complete Debt Guide will be able to get this already. If you want to slow it down and write this stuff down, by all means do it. But if you don't want to write it down, go ahead and spend the $47, grab the Complete Debt Guide. It's all going to be in there. Now, just to break down the legal framework that backs up this entire process, and again, this is not legal advice. I have to keep repeating that because this is just for educational purposes only, things that I found online. All right. And if online can't give you legal advice, then essentially this is not legal advice. This is educational. You can go online and find this information yourself. I just put it all together for you. You dig me? And let's talk about it. UCC 3-603. Okay. Obligation is discharged when payment is tendered. Okay. That is the whole point. It says that when you send in a payment and it is refused, then there's discharge under UCC 3-603. You can write that up and look it up yourself. Then when you dive into UCC 3-505, it says dishonor occurs when a payment is refused. So if someone ignores you or they refuse it, then you notify them of their dishonor, and it's backed up by UCC 3-505. Then when it comes to the aspect of validating debt, under 15 USC 1692G, it says that debt must be validated. And if it is not validated, then it's not a valid debt. Okay? So debt collectors have a responsibility to be able to validate debt no matter what. Then we dive into the UCC Article 1, Section 10, which essentially is saying that you have a right to contract privately. You have a right to send these letters to these companies and have a private communication between you and the debt collector and put them in a position of and be able to build your evidence, build your case. If they decide not to dispute this debt privately and you have to take it to court, you have a right to use this evidence in court. Okay? And then lastly, under the Truth in Lending Act, under the FDCPA, they must provide full disclosure and practice fair collection practices in order for them to collect on the debt, in order for them to be moving properly. There are some strict guidelines in the Constitution that not only protects you, but gives them specific rules and regulations that they must follow, such as the disclosures, such as the aspect of the fair collection practices, such as the aspect of them not harassing you and doing things, misrepresenting, lying to you, because there are certain things that they'll do to you that they not only will have civil liability where they can be fined thousands of dollars per violation, but now when it comes to the Truth in Lending Act, when they start lying about certain disclosures or lying about who they are and misrepresenting, that's actually criminal liability, and they can be imprisoned for their lies. Okay, so now that you guys understand that conditional acceptance puts you back in control and makes them prove any and everything, and when they can't, you have created a legal record that clears your name and protects your rights, regardless if you go private, regardless if you get ownership over the straw man, regardless if you do any of these things. If you could do this conditional acceptance process, you will be in more of a place to communicate with the debt collector and negotiate with a debt collector. That's the whole thing. It's a negotiation battle. And if you understand the aspect of negotiation, you're a strong negotiator, you're a strong person that keeps their document and organizing their documents, all you have to do is be able to present this evidence in court and know and understand what you're talking about. If you know and understand what you are talking about, they cannot take advantage of you. Okay? So now, if you want my done for you conditional acceptance template plus my payment voucher kit, it is in a complete debt guide for only $47. Okay, if you want to learn how to exercise the administrative process, understand negotiable instruments, understand securities, understand different laws that back this up, tap in with the complete debt guide. You want more of a deeper control understanding, but then also at the same time, man, you want this for a lifetime. Who knows? These videos may be gone someday. Okay, or may get lost. All right, because think about it, a lot of times people are taking this information for granted, but trust and believe, I'm gonna make sure this stuff is safe. Grab the complete debt guide for only $47. Number two, if you need help using this strategy for a specific account, tap in with Solo Suit down below. The link is in the description. Solo Suit, yes, they won't be able to sit there and discharge debt and things of that nature, but they can help you with the debt validation process. They can help protect you against lawsuits and things of that nature. When it comes to that one-on-one mentorship, you can apply down below. Now, my one-on-one mentorship is geared towards entrepreneurs who want to fix their credit, get funding, and also wants to grow their business. And part of that, if a person is a part of my mentorship, my private coaching experience, yes, I'll wholeheartedly give you the game and teach you this, but it's not the premise of what I do. Okay, so if you're looking to just discharge debt and things of that nature, just tap in with the complete debt guide. I wouldn't advise anybody to tap in with my one-on-one mentorship if you have a debt to be cleared and you don't know and understand the risk. Okay, and looking for someone to do it for you. I'm sorry, that's not something I'll do. Tap in with Solo Suit. And then lastly, if you want to connect with me on a more consistent basis, tap into my Instagram at biz.nick. And my last question is, have you ever used conditional acceptance before? Tell me your experience in the comment section, or let me know what you want me to cover next. Remember to like, subscribe, turn on the post notifications. This is the kind of info that they don't want you to have, and I'm giving it to you for free. If you got all the way to the end, comment the word discharge, comment the word conditional, and I'll see you in the next one.